Right, good morning and welcome to the second day of the Criminalising Surrogacy Conference. This morning our first stops will be India and Thailand in this world tour of surrogacy. My name is Joanne Brown and I have the great pleasure of introducing Sanskriti Sanghi, who will be speaking on India, and Shaati Chandramour, who will be speaking on Thailand. Just do a brief introduction and then I'll pass the panel over to the speakers. So Sanskriti is an independent researcher residing in London, United Kingdom. She's currently the Policy and Campaigns and Communications Officer at the Southall Black Sisters, a bi and for Black minoritized and migrants women's organization addressing domestic abuse and other forms of gender-based abuse. Through campaigning for legal and policy reform and strategic litigation, as well as through frontline support. Until 2023, Sanskriti was the Assistant Professor of Law at the Jindal Global Law School in India. Her research interests include critical legal theory, international human rights law, climate change law, and family law. Sanskriti's research has been published in renowned journals, including the Asian Journal of International Law, the Asia Pacific Law Review, and she has also contributed to major comparative family law studies on the legal status of de facto relationships with Jens, of course, and Andy Hayward, and Parenthood, edited by Claire. So we've got a lot of, similarities in the room, I think, from yesterday and today. In the past, Sanskriti has also served on the editorial board for the Jindal Global Law Review and worked with the Columbia Global Freedom of Expression and the Institute for Internet and the Just Right. Chat serves currently as a full-time assistant professor at the Faculty of Law in Thammasat University. He's the director of the International Law Association of Thailand and teaches and researches conflict of law, family law, and international and economic law. Chat, also known as Joe, formerly used to work in activism for the LGBTQI and sex workers community. He's previously been involved in legislative drafting for local laws and also serves as a part-time counsellor for public and private sectors. So thank you. So over to you, Ms. Witt.
Thanks, Joanne. Good morning. It is both a pleasure and an honor to be here today to discuss India's regulatory framework governing surrogacy, with an emphasis on the actions and actors that are criminalized in the pursuit of achieving altruistic surrogacy alone, or rather outlawing commercial surrogacy. During the course of my presentation, I will be discussing the trajectory of India's transition from a free market jurisdiction to a regulatory framework, one that raises pertinent questions about heteronormative visualizations of family structures, the value of reproductive labor, the deterrent quality of legislation in ignorance of local realities as mapped by empirical research, and the role of law in moralizing and moral adjudication. This is a framework that continues to be in flux. The Supreme Court of India is currently tasked with debating the merits of a constitutional challenge to foundational aspects of the framework. The examination of surrogacy in India thus requires recourse not only to family law, but also to constitutional law and legal theory. We begin by first thinking about India's approach to surrogacy. And as I just mentioned, it's definitely a tale of transitions. So currently, the Surrogacy Regulation Act, or the SRA, and the Assisted Reproductive Technology Regulation Act, or the ARTRA, enacted in 2021, govern surrogacy in India. The SRA is intended to govern the social, legal, ethical, and moral aspects, while the ARTRA is intended to govern the technical and medical aspects, thus requiring a conjoined reading of the two acts. As per the SRA, altruistic surrogacy is the only type of surrogacy permitted in India. The enactment of the SRA in the ARTRA marks a sea change. The road to regulation has been long drawn and fraught with anxieties. The states, as well as other stakeholders, primarily the intending parents and surrogate mothers, as well as the surrogate child. In the early 2000s, in the absence of a regulatory framework, the national guidelines for accreditation, supervision, and regulation of ART clinics in India, developed by the Indian Council of Medical Research, emerged as guidance, albeit non-binding. These were accompanied by executive orders issued from time to time by various Indian federal ministries. During this time, and of course, there's a lack of data transparency in India, so this is perhaps the only statistic available. But during this time, India was one of the largest providers of commercial surrogacy globally, with incidents tripling between 2007 to 2009. Concerns about commercial surrogacy arose due to key developments in cases such as the Baby Marji Yamada case in 2008 and the Jan Bilaz case in 2009, both of which entailed a transnational element, Japan in the first instance and Germany in the other. The cases exposed the urgent need for regulation amidst concerns of surrogate children's statelessness and the exploitation of surrogate mothers. As a result, the Law Commission of India submitted the 228th report, in which it recommended legislative intervention with the objective of legalizing altruistic surrogacy arrangements and banning commercial ones. In 2012, the Ministry of Home Affairs issued a directive requiring foreign couples to obtain a medical visa prior to initiating surrogacy and an exit visa upon conclusion. This was superseded by a circular that was issued in 2015 that banned foreign couples altogether from availing surrogacy. The circular was issued amidst an ongoing public interest litigation seeking a prohibition on commercial surrogacy. And so the action of citizens taking a pushback against the state's regulatory framework is a recurring theme across India's tale of transitions. These developments informed the SRA and the ATRA, as well as the draft bills in the lead up to their enactment, primarily the 2016 and 2019 bills in the context of the Surrogacy Regulation Bill. We now come to thinking about the types of surrogacy, eligibility, and effects, and the way that they're regulated under the current framework. So altruistic surrogacy alone, which is defined as surrogacy in which no charges, expenses, fees, remuneration, or monetary incentive of whatever nature, except the medical expenses and such other prescribed expenses incurred on surrogate mothers and the insurance cover for the surrogate mother is permitted in India. Neither the SRA nor the ATRA contemplates Indians going abroad to commission surrogacy at all. The ATRA facilitates the transfer of intending parents' own gametes and embryos for personal use in the event of a change in residence, and that's the only regulation in any form in the framework. In terms of contemplating India as a destination for transnational surrogacy, the SRA permits couples of Indian origin, understood to mean couples in which both the husband and wife are overseas citizen of India card holders, to commission surrogacy strictly in accordance with the altruistic regulatory framework. Altruistic surrogacy can be commissioned only by a married heterosexual Indian couple with a medical indication necessitating gestational surrogacy, where the woman is aged between 23 to 50 years and the man is aged between 26 to 55 years, or by an Indian woman who is a widow or divorcee aged between 35 to 45 years. Before surrogacy procedures can be initiated, intending parents are required to obtain a range of different state-issued documents. These include a certificate of essentiality confirming a medical indication, order concerning the parentage and custody of the surrogate child, insurance cover for the surrogate mother, and a certificate of recommendation from the National Assisted Reproductive Technology and Surrogacy Board. Intending parents must also procure an eligibility certificate that confirms the fulfillment of eligibility conditions and that the intending parents have no surviving child unless the child is quote-unquote mentally or physically challenged or suffers from life-threatening disorder or fatal illness with no permanent cure, which, if we take recourse to disability studies, continues to place children with disabilities in the range of the abnormal and treats them as lesser than other children. A married woman aged between 25 to 35 years with a child of her own who is willing to bear a child for the intending parents through surrogacy can be a surrogate mother. So she must be, as the Act puts it, an ever married woman with a child of her own. The surrogate mother must obtain an eligibility certificate prior to the initiation of surrogacy procedures. She must fulfill additional criteria that must be recorded in writing, including that she shall not act as a surrogate mother by providing her own gametes, will serve as a surrogate only once in her lifetime, and that she is medically and psychologically fit as approved by a registered medical practitioner. Safeguards for the surrogate mother, despite being the purported intent of the Act, are limited to a provision on the right to informed consent that, as I'll mention further, gets overruled by another provision, and to withdraw from surrogacy only before the implantation of the embryo in her womb. A surrogate child shall be deemed to be, in terms of effects, to be the biological child of the intending parents and shall be entitled to all the rights and privileges guaranteed to a natural child under Indian law. This recognition flows from the order concerning the parentage and custody of the child, required to be obtained prior to the initiation of surrogacy procedures, which serves as the surrogate child's birth affidavit. In the event of a donor gamete, donors shall relinquish all parental rights over surrogate children. We now come to perhaps what's the densest part of this act, because the main way in which this framework attempts to regulate and outlaw commercial surrogacy is through criminal sanctions. And there are many, many of those, both generally to any person and also quite specifically to certain actors. But we begin first by thinking about whether there's been any discussion on the aim and purpose of these sanctions at all. So in the years leading up to the enactment of the regulatory framework, as I mentioned, India emerged as a hub for commercial surrogacy arrangements. During this period, several incidents of unethical practices by service providers raised concerns about the exploitation of surrogate mothers and children and led to widespread condemnation of the rampant commercialization of surrogacy, both within India and abroad. Instead of banning the practice of surrogacy altogether due to the risk of driving it underground, regulation with permission for altruistic surrogacy alone was thought to be the better solution. The Law Commission of India had recommended this approach in its 228th report, terming it as the balance the law must strike between being an ardent defender of human liberty and an instrument of distribution of positive entitlements. The regulatory framework is thus intended to protect the rights of surrogate mothers and children and facilitate access to the benefits of emerging technologies solely to those in need, principally through the deterrence of remunerated surrogacy by means of stringent criminal sanctions. And we now come to the many, many sanctions that are encoded in the legislative framework. So Chapter 7 of the SRA and Chapter 5 of the ARTRA detail the actions regarding surrogacy that are subject to sanction. While certain provisions are more general in that they are applicable to any person, other provisions are targeted towards specified actors such as intending parents, surrogacy or ART clinics, medical practitioners, and so on. Under the SRA, prohibited actions include undertaking or advertising commercial surrogacy, transacting in human embryos or gametes, exploiting the surrogate mother or child, abandoning the surrogate child, and conducting sex selection. Contravention of any of these prohibitions is punishable with imprisonment for up to 10 years and a fine extending to 10 lakh rupees, which is approximately 10,000 GBP. Seeking the aid of a surrogacy clinic, laboratory, or registered medical practitioner, gynecologist, pediatrician, embryologist, or any other person for commercial surrogacy is punishable with a term of up to 5 years and a fine extending to 5 lakh rupees for the first offense, and with imprisonment for a term of up to 10 years and a fine extending to 10 lakh rupees for a subsequent offense. Contravention of any provisions of the Act for which no penalty has been prescribed, the residual penalty clause, is punishable with imprisonment for up to 3 years and a fine extending to 5 lakh rupees, with an additional fine of up to 10,000 rupees for each day of continued contravention after conviction for the first offense. While intending parents can be punished for any of these contraventions, the scheme of the SRA suggests the likelihood of them attracting penalty for pursuing commercial surrogacy, exploiting the surrogate mother or child, abandoning the child, and conducting sex selection. Other sanctionable actions include causation of abortion by intending parents without the surrogate mother's consent and requisite authorization, and the storage of a human embryo for surrogacy purposes other than as legal, which are subject to the residual penalty clause. Surrogacy clinics are subject to a sanction for a range of actions, including conducting surrogacy procedures if unregistered and employing or taking the services of any person without the requisite qualifications. Surrogacy clinics, registered medical practitioners, gynecologists, pediatricians, embryologists are also prohibited from engaging in commercial surrogacy, participating in the conduct of surrogacy directly or through any other person at a place other than as registered under the Act, promoting commercial surrogacy, inducing or indicating agreement to be a surrogate, conducting or causing abortion during a period of pregnancy, storing a human embryo or gamete other than as legally prescribed, and conducting sex selection. Medical professionals in continued contravention of the provision of the SRA shall also be reported to the State Medical Council and be subjected to necessary action, including the suspension of their registration as medical practitioners for a duration of 5 years. Medical practitioners are additionally subject to penalties under Chapter 5 of the ARTRA. ART clinics, for instance, are forbidden from advertising sex-selective assisted reproductive technology and can be held liable for the offense through the executive head of the clinic unless it is proved that he had no knowledge or had exercised due diligence to prevent the offense. In this case, an employee found to have connived or whose neglect led to the commission of the offense will instead be punished. The offense is liable to be punished with imprisonment between 5 to 10 years or with a fine between 10 and 25 lakh rupees or with both. Medical professionals such as geneticists, gynecologists, registered medical practitioners are also prohibited from abandoning a child born through ART, exploiting the intending parents or gamete donors, importing, selling, purchasing, trading in human embryos or gametes, using intermediaries to obtain or purchase gamete donors, and transferring human embryos into a male animal or person. This is punishable with a fine between 5 and 10 lakh rupees for a first offense, and with imprisonment for a term between 3 to 8 years, and with a fine between 10 and 25 lakh rupees for a subsequent offense. Any agents, intermediaries, or advisors other than those provided for specifically under the provisions of the SRA and the ARTRA are subsumed under the ambit of any person, which doesn't get defined in the Act, or any organization. Neither Act provides clarities on who these additional actors might be, and this hasn't been debated in any of the reports either. And ambiguity abounds further because the legislation continues to carry traces of words such as agents, sometimes used in the context of insurance, but completely undefined. While it can be argued that the surrogate mother is subject to sanction by virtue of falling under the ambit of any person, the scheme of the Act suggests otherwise, and this is part of the protectionist approach that the state takes instead of treating her as an actor with agency. And this is particularly evident in a legal presumption of compulsion on the surrogate mother from the intending parents, her husband, or any relative in the event of commercial surrogacy, suggesting not only that the social norms that operate on women prevent them from ever being able to provide informed consent, but also indicating that the state is absolutely justified in taking a protectionist and paternalistic approach to her well-being. Though the provision is intended to safeguard her, in positioning her as an actor without agency over decision-making about her own body and reproductive autonomy, the SRA acts as a vehicle for state paternalism and also contravenes the earlier provision on informed consent. The regulatory framework does not explicitly contemplate the consequences for parenthood and parenting in cases of criminalized surrogacy at all. Instead, it endeavors to deter instances of criminalized surrogacy altogether and includes in its purview a range of actions subject to sanction, not all of which attract consequences regarding parenthood and parenting. We need to look at the acceptable excuses and justifications as well. And I think this is a really interesting bit in the current Indian framework, because the question of whether there are acceptable excuses or justifications can't be answered in a yes or no at the moment in India. In fact, it gets broken down or bifurcated into two questions. One, are there any acceptable excuses or justifications to the type of surrogacy that can be commissioned, and whether there are any acceptable excuses or justifications to any other parts of the law, for instance, eligibility requirements. And so there are no acceptable excuses or justifications in statute or case law to the type of surrogacy that can be commissioned. However, courts have interpreted the regulatory framework liberally while adjudicating on challenges pertaining to the eligibility criteria to be parents, with the intent of expanding beneficiaries, albeit within the heteronormative vision. In a decision delivered by the Karnataka High Court in 2023, the age criteria, for instance, in the SRA was relaxed in favor of an old couple's desire to become parents through surrogacy due to the loss of their only son in a road traffic accident. In another decision, Arun Muthuwal in 2023, the Supreme Court stayed an amendment to the rules accompanying the SRA that required an intending couple undergoing surrogacy to use their own gametes on the ground that the amendment conflicted with the import of the term medical indication. And so, under the garb of ironing out creases in the legislation, these decisions, and there are two more which do this more squarely, they've started placing this jurisprudence in the context of reproductive autonomy as constitutional jurisprudence. In XYZ and another in 2024, the Bombay High Court reiterated this decision in Arumuthuval, situating intending parents' desires to be parents in the wider context of reproductive health as a facet of personal liberty guaranteed by the Indian Constitution. In Ravikant Chauhan in 2023, the Delhi High Court similarly granted intending parents interim relief, adding that the amendment had the effect of discriminating between infertile couples on the basis of their ability to produce viable oocytes without a rational justification or intelligible criteria. It is worth noting, however, that across these decisions, intending parents' compliance with other provisions of the SRA, in particular, the surrogate mother's fulfillment of eligibility criteria, such as being an ever married woman, was pivotal to the grant of the relief, as was the idea of altruism itself, thereby indicating that courts have discretion, but it's limited in the way that it's exercised. We now come to thinking about how we can evaluate this framework and what the early signs are, given that this was only enacted in 2021, and the rules that accompany it that, again, further clarified a few aspects of the legislative framework came only in 2022. So because of the recent enactment of the SRA and the ARTRA, there are no prosecutions thus far, despite the number of criminal offenses that are outlined to gauge the efficacy of the punitive provisions. Concerns about the emergence of a black market abound, particularly amidst fierce critique of a carceral approach to regulation, the devaluation of labor in an altruistic model, ignorance of local realities of economic hardship, subsistence of strong informal intermediary networks that subsisted during the time India was primarily a commercial surrogacy jurisdiction, and the lacunae in implementation. The lack of readily available data on trends in the commissioning of surrogacy compounds the difficulty of any analysis of efficacy. So we now begin to think about the way forward, and the way forward currently looks like a continued legal battlefield and a continuing tale of transitions. It might be evident to you by now that over the past 2 decades, India has undergone a significant modal shift from one end of the spectrum to the other, from a free market framework to a regulatory one with punitive provisions for any deviations from the prescribed mode of altruistic surrogacy. The choices encoded in the current legal framework are, however, not without debate. A continued point of contention is the choice of altruism itself. In its report on the Surrogacy Regulation Bill 2016, the department-related Parliamentary Standing Committee on Health and Welfare recommended the adoption of the compensated model, noting that the preference for the altruistic model appeared to be based on quote-unquote moralistic assumptions than on scientific criteria, and that all kinds of value judgments had been injected into it in a paternalistic manner. The PSC recommended adequate and reasonable compensation for lost wages for the surrogate mother. The due consideration for women's reproductive labor accorded by the PSC failed to find way into the Surrogacy Regulation Bill 2019. In the Select Committee's report on the Surrogacy Regulation Bill 2019, it noted stakeholders' objections to this on the grounds of the promotion of altruism as the promotion of forced labor that exacts physical and emotional tolls on the woman, free of cost and only out of so-called compassion. The Select Committee, despite noting these concerns, recommended retaining the altruistic model, reasoning that it would ensure that the quote-unquote noble act of motherhood is not commodified, and so that the surrogate mother can, quote-unquote, set an example of being a model woman in the society, indulging in altruistic and selfless acts as other normal mothers do, thereby reproducing the moralistic tone and the paternalism that the PSC had advised against. The choice of altruism, thus, in the way that it's envisaged currently, compels women to conform to patriarchal assumptions while limiting their livelihood options. This concern is amplified due to a requirement that the surrogate mother be an ever-married woman having a child of her own, a condition which imposes the social norm of marriage as a precondition to the exercise of reproductive autonomy. The government's decision to ban commercial surrogacy in favor of a purely altruistic model is currently under challenge before the Supreme Court of India. The next bit that's particularly contentious is the exclusion of individuals who are desirous of becoming parents through surrogacy due to their deviation from the heteronormative visualization of family structures institutionalized in the regulatory framework. Those excluded include couples in live-in or cohabiting relationships, same-sex couples, single women that are not widowed or divorced, and single men. And despite being in the interest of trying to take care of the 228 report's ideas of balancing human liberty and the distribution of positive entitlements, these exclusions don't quite see how these two ideas can't be reconciled by granting parenthood to these categories of individuals as well. During the debate on the Surrogacy Regulation Bill 2016, despite the BSC's recommendation that the eligibility criteria should be broadened to include families that are representative of the quote-unquote model social milieu, the Select Committee advised against it in the best interests of the child. During its review of the Assisted Reproductive Technology Regulation Bill 2020, they advised against extending the right to avail ART services to cohabiting and same-sex couples in the best interests of the child, as given Indian family structures, acceptable norms, and social milieu, it would not be easy for Indian society to accept a child whose parents are together but not legally married. These exclusions are now being challenged on the touchstone of the constitutional principles of equality and non-discrimination and the right to reproductive autonomy and privacy. Though the outcome of the legal challenge remains to be seen, the landscape of surrogacy regulation in India promises to continue to evolve with pushback against the state's heteronormative paternalism by the people. Thank you.
So very good morning, everyone. First of all, I would like to thank the organizing committee for organizing such a great event. And thank you so much, all participants, for wonderful presentations, as well as the writings I have read and learned a lot. I need to confess something. This is my first time doing the surrogacy research. I have been teaching family laws and doing the gender and family stuff like for many years. And it's quite a challenging topic for me. Welcome all feedbacks for my presentation as well as my writing. So I'm going to talk about the criminalization in Thailand. So first talk about some historical background and then some selected questions and evaluate on the sanctions that Thailand have. That we have several kinds of sanctions, not only the criminal sanctions, but also administrative measures and some self-regulated regimes. And also conclusions. Okay. Well, actually, Thailand has the current law, which is the law 2015 Act, which is the general framework for the surrogacy. But before the time, we had our regulation, which is actually self-regulated regime. Actually, we let the Medical Council of Thailand pass its own regulations and have the self-regulated regimes on the issues of the surrogacies. Well, and we also apply, some law of human traffickings, on some stuff that related to human trafficking on aspect of surrogacy as well. The first case, okay. Actually, the first case that actually it's not the court, but actually the Council of State in Thailand has known about the surrogacy is in year 2000. A couple of intended parents who work in the public sector hire a surrogate mother to give birth to a baby, and they requested for public welfare for their newborn. And this would be successful if the legitimacy is recognized by the authority. But unfortunately, the authority refused the relationship and finds that only the surrogate mother has juridical ties with the newborn because she gave birth to the baby. So the principle of mater semper certa est has been affirmed for this case, and it was criticized by academics and that leads to some changes in the legal framework. And then not only this case, but also the baby gammy. I think many of you have heard about it, and I got the inputs from colleagues that you are interested to listen to about this case, baby gammy, and the Japanese kind with 13 babies. he hired the surrogate mother in Thailand to have the 13 baby for them. Okay, so I begin with the first case, Japanese guy with his 13 babies. A Japanese businessman hired a number of both Thai and non-Thai ladies to serve as a surrogate mothers for 13 babies. These babies are expected to grow up and take care of his business in the future. Well, expected to be businessman, businesswoman in the future. And the Thai public prosecution officers came to investigate in his apartment and alleged this businessman as committing a human trafficking. We had a human trafficking law at that moment, but we didn't have the surrogacy law at that moment. The case was brought to the court. The court decided for the Japanese guy for both civil and criminal aspects of the case. The guy is held to be legal parent of all the babies. He is not criminally liable. The surrogacy contract was done and the gestation occurred before the passing of the Protection of a Child Born by Medically Assisted Reproductive Technology Act, or the Act 2015 PCMART. Okay, so this one, and the next one is bigamy case. Well, bigamy case seems to be interesting because the news in Thai language and also in the English language say something quite different from one another, and then the fact is not yet settled even nowadays. I am not sure. We need to interview all the people there. I talk a little bit about the bigamy case. The surrogacy contract was concluded between the couple of Australian intended parents, last name Funnels, and the Thai surrogate mother, Chandramour. During the gestation, the twins of male and female were shown up. The female embryo was normal, but the male detected with Down syndrome. The intended parents requested for the abortion of the male embryo. The surrogate mother refused to do so. After the birth of the babies, Pipa and Gami, Pipa is female and Gami is male, were separated. Pipa was brought to Australia and Gami left in Thailand. The fact widespread quite fast. A lot of people believe that the Australian parents actually intended to leave baby Gami with Chandramour, the surrogate mother. The alleged story draws global attention and attracts a lot of transfer a lot of money to the trust fund established to take care of the baby. Legitimacy of finals to the babies were contested before Australian court. It ruled for finals on the legitimacy legal matter, and on factual matter, it also found that the family did not abandon the child. Many cast doubts on the ruling of the court because I read the Thai news. The story is said differently, from the Western news, and also even though amongst the Western news, in English they say something so different, and the fact is not settled. But okay, although baby Gami remains with her surrogate mother. Okay, and with these cases, case Japanese guide and the baby Gami case led to the enactment of the law, general framework on the surrogacy, which is PCMART. Okay, and I select some questions to talk about. Okay, I'm gonna talk. Okay, the first, I think it's very similar to many jurisdictions. Only non-commercial surrogacy permitted, and it's stated quite clear in section 24. As you see on the PowerPoint, and the violation leads to the maximum sentence of 10 years and or fine of not more than 200,000 baht. Ban those acting of the act of intermediaries of all kinds. But it's not actually applied to the intended parents and the surrogate mother at all. Okay. But this one is kind of doubtful whether or not, to what extent it can be interpreted and extended, what can be done. Because here, reasonable compensation can be given, but remuneration is not allowed. So we must interpret And right now, there is no case law concerning this matter. And there are also specific requirements as regards, commercial stuff. For example, Section 41, no person shall propose to purchase, sell, import, or export sperm, oocyte, or an embryo. The violation leads to the maximum sentence of 3 years and or fine not exceeding 60,000 baht. Okay, and the surrogacy can be done, but with some requirements. Okay, a requirement has been important actually for medical professional, intended parents, surrogate mother, and donors as well. And you can see some very detailed, and these are actually detailed by the physicians, not drafted by the lawyers, as far as I have researched. So the medical professionals, well, very shortly speaking, but it's actually broad, non-compliance with any rule or provision in the legislative act or cause disciplinary action to initiate, and also criminal sanction against medical professionals. Whereas surrogate mother and intended parents are generally excluded from the sentences. Intended parents, they must be married couples, and this is not possible for single mom or single dad at all in Thailand. And they must have fertility hardship from either side, and both need to be Thai national. Both need to be Thai nationals. Perhaps because the experience of Thailand having a lot of foreigners coming a long time ago, and then we had a lot of clinics that accommodate, and we want to eradicate this from the country. I'm not sure whether it's successful. Okay, both have to be Thai nationals or acquire the nationality no less than 3 years. And for surrogate mother, there are some steps to take. Now, surrogate mother must be relative of either male or female spouse, and not ascendant or descendant of either side. And a person, if these cannot be found, okay, if he or she, if she cannot be found, a person outside of the family can be the surrogate mother as well. And the surrogate mother shall have lawful husband or cohabitant, and his consent must be obtained before the service. The surrogate mother has given birth to a child before the surrogacy. I think this is similar to Indian version. Violation of a rule leads to ethical action against the medical professionals, not the surrogate mother. Requirements for the donors, okay? The donor must not be the medical professional. Of course, it is written down in notification because the doctor have designed the framework. No person with the genetic type, the age is between 20 and 45 years old, and also physically, psychologically healthy. And this is, I'm going to talk about the process as well because they have the process of investigation. And no genetically transmitted disease, no HIV, never used drug, not being promiscuous. This is so difficult to elaborate, I don't know, but it's written down in the doctoral notification. It's become a regulation right now. And for the process, there's going to be medical investigation. And this is to examine biologically and psychologically, I mean, all persons concerned, including donors. Physician must prevent any disease to be transmitted to the child, and can consult with the intended parents and also the surrogate mother if something happened and the gestation might be terminated. Sex selection is prohibited. I think quite similar to Indian versions as well. If all satisfied, the end result, okay. If satisfied, no sanction by law. If not, criminal, administrative, or civil law sanction may take place. Criminal law and private law problems are generally separated in the eyes of BCMART. So we don't have any kind of civil law sanctions. Okay, we separate between the criminality and the civil law part. Okay, and then we talk about the sanctions. The sanction, forms of the sanction, is it workable? Thailand, I admitted that Thailand does not focus very much on the criminal sanction. We have various kind of sanctions, and we let the physicians decide the legal framework also. Well, even though right now we have the legislation, but the legislation leaves the room for the physicians to decide some detailed regulations on some detailed stuff. We have criminal law sanction, of course, and then we also have administrative law measures, okay, and self-regulated regime. For the criminal law sanctions, interesting, excluded the intended parents, surrogate mother, all the process. And it's applied actually against the medical professionals, intermediaries, somebody surrounding, not the person involved directly. And so conventions found, well, evaluate from what I have been done. I have not yet done the research, the field research, but I think this is quite necessary in Thailand as well, because I read from the law, but the reality is something quite different. There are still underground clinics, and vulnerable women are abused, especially the refugee. If you have heard the news in Thailand, there are refugees, Rohingya people, and they were abused through human trafficking. Manipulation of connecting factor. Well, I'm conflicts scholar by nature, and I teach conflict of laws. I use the term manipulation of connecting factors. So people still choose the jurisdiction they would like to do the surrogacy if they want to not to comply with the Thai law. And as we know that after Thai law has been passed, surrogacy has been moved to Cambodia, Myanmar, and Laos instead. And then the couples come back to Thailand. Okay, and the Thai law does not have long arm enough to regulate all the aspect. Of course, it has limits, and the laws. It's quite clear if you read from the law that, okay, the limits solely apply in Thailand and there is no sanction against international surrogacy. And also it sometimes is inserted as part of complex crime, money laundering, human trafficking, and so on. Well, as I told you, okay, we also have administrative law measures, which are applied, I think it's more intensively than the criminal law measures. Interestingly, talk to the criminal law professors. They said that they prefer administrative law sanctions rather than the criminal sanctions. The criminal sanction in Thailand requires a long process and a lot of money you invest on the cost of the prosecution. Interesting. Well, we have Ministry of Public Health and Ministry of Social Development and Human Security. According to the law that exercise their power in conjunction with their own laws. Well, with the law, this one, the Surrogacy Act and their own law. And also we have the self-regulatory system, the Medical Council of Thailand, as the Surrogacy Act allows, they can enact their own, well, they call notification, but the way it works, very similar to regulations. And conclusion, asks the question, what about criminalization? Does it dissuade people from committing the crimes? Well, I'm not sure. If we have a look, the criminality is actually put on the medical professionals, intermediary and surrounding people. Intended parents are criminally responsible in very few cases, like buying or importing sperm or oocyte. Law on the paper and law in reality. We should have field research because reading the law and then seeing something in real life, I think you're going to see something quite contradictory. And I think we need some time to do the field research. And the low cost of enforceability is something that a third world country always think about when we enact legislation. We think about how to make it work in the reality. And that is also part of the decision, I think, that the legislature decided not to use so much criminal sanctions against surrogacy. Third world limits, optimal choice is something that we have counted, and we have to reach the target with the lowest cost. And what is the appropriate approach? Think about the third world limits and the context, and diversify the legal measures. Criminal sanctions, as I told you, that persecution costs a lot of money in Thailand, and a lot of people have to involved. So we use administrative measures as well. And collective consciousness might be also effective. Teaching the physicians very early in the medical school might be a solution as well, alongside other measures. Okay, thank you so much.
Okay, good morning, everyone. Welcome to this panel session 7. And in this session, we'll look into the legal and practical situation in Hong Kong, Singapore, and Malaysia. And let me briefly introduce myself. My name is Lisa Wong. I'm a family lawyer. I've done quite a number of surrogacy cases in Hong Kong. And we've got a group of very esteemed speakers today. And before we go into our presentation and discussion, let me very briefly introduce them. And I encourage you to check out their detailed profile in the program. So sitting on my far left is Ms. Yuxin Tian. Ms. Yuxin Tian is a 4th-year undergraduate law student at the University of Tokyo's Faculty of Law. During her exchange year at the LSE, London School of Economics, Yuxin worked closely with Surrogacy UK, a local NPO focused on altruistic surrogacy, and conducted her independent ethnographic project on UK surrogacy law reform in London. And then next we have Professor Daisy Cheng. Professor Cheng is an assistant professor of law and deputy director and research fellow at the Center for Medical Ethics and Law, the University of Hong Kong. Daisy's research interests lie in healthcare law and ethics, with a primary focus on mental health and capacity law and ethics. She has published on various mental health ethics and mental capacity law, and has also written on regulations of surrogacy in the Hong Kong context. Next, we have Ms. Henry Cha. Ms. Cha is a Sheridan Fellow at the National University of Singapore Faculty of Law. She holds a Master of Bioethics from Harvard Medical School and previously practiced law in Singapore as a medical defense counsel. She's currently pursuing a Doctor of Philosophy in Law at the University of Oxford. She has published articles in the Medical Law Review and the International Journal of Law, Policy and the Family. And then, last but not least, of course, is a representative from Malaysia, Dr. Chee Ying. Dr. Kuek is a senior lecturer at the Faculty of Law, University of Malaya, Malaysia. She holds a Doctor of Philosophy from University of Malaya. Her main research interests are in medical law and ethics, family law, probate, and administration. She has undertaken studies on ethical and legal issues relating to selective reproduction, reproductive technology, and children. And she's recently studying on the ethical and legal issues arising from artificial intelligence. So, without further ado, I would like to pass the floor to our Hong Kong representatives, Ms. Yuxin and Daisy, to talk about the Hong Kong perspective.
Thank you so much. Good morning, everyone. Especially thanks to the organizers for the opportunity. Presenting on my first conference here in Hong Kong feels like the perfect way to introduce this method and Hong Kong law framework. So today, Daisy and I will be introducing Hong Kong's legal framework on the criminalization of surrogacy, as well as some recent developments in the area. So briefly, I will be stating our discussion. I will walk you through the general legal framework of criminal sanctions and this will over from there for more specifics regarding parenthood and custody. From this legal framework, governing services in Hong Kong is anchored in the Human Reproductive Technology Ordinance. This ordinance lays down strict prohibitions and limitations on service arrangements. While certain forms of services are permitted, the HRTO establishes a highly restrictive environment, particularly regarding the use of reproductive technology. So one of the fundamental restrictions under Hong Kong law is that only the genetic material of the commissioning parents may be used in a service arrangement. And this is enshrined in Section 14, which prohibits the use of donated germs, whether eggs or sperm, in any service arrangement. Therefore, forms of service where the certain level is genetically related to the child, such as traditional service, are strictly forbidden. The only permits gestational service where the service carries the child that is genetically linked to both commissioning parents. It should not involve third-party donors. This is, however, different in scope compared to the threshold to apply parent, which we will address later in the session. And following that, Section 15, Paragraph 5, imposes further limitations on who can access reproductive technology procedures. In Hong Kong, only couples are allowed to use these procedures, including surrogacy. And unmarried individuals and couples are explicitly barred from accessing surrogacy, even though the surrogate mother herself is not subject to the marriage requirement. And moreover, the law prohibits the use of reproductive technology procedures posthumously. In other words, the surviving spouse cannot use the deceased partner's reproductive material to conceive a child through surrogacy. And this prohibition is maintaining the legal requirement for both parents living at the time of surrogacy arrangement. Furthermore, perhaps the most stringent aspect of Hong Kong's surrogacy law is the absolute prohibition on commercial surrogacy. Section 16 of the HRTO makes it illegal to engage in any commercial dealings involving prescribed substances, which include genes, embryos, or other reproductive materials intended for surrogacy. Section 17 takes the prohibition a step further by criminalizing the arrangement and negotiation of service arrangements for commercial purposes. Under the HRTO, violations of the prohibitions of performance and institute services are considered criminal offenses that carry significant penalties. For a first conviction, offenders are subject to imprisonment for up to 6 months and a fine of 2,500 Hong Kong dollars. For any subsequent conviction, the penalty is increased to imprisonment for up to 2 years and a fine to 100,000 Hong Kong dollars. It is important to note that there is no differentiation in the type or level of criminal sanctions based on the unit of individuals involved. The commissioning parent, the surrogate mother, an intermediate agency, or medical professional, the penalties remain the same. The legislative intent behind criminalizing service in Hong Kong is clear, which is to prevent the commercialization of surrogacy. The legislative discussions preceding the enactment of the HRTO emphasize the strong consensus against commercial surrogacy. Lawmakers express concerns that allowing financial remuneration for surrogacy would open the door to the commodification of reproduction, and the government adopted a broad definition of the term payment, covering all forms of compensation with only a narrow exception for reasonable expenses related to the pregnancy and delivery of the child. And despite the broad definition of payment, some legislators voiced concerns that special arrangements be made to circumvent the prohibition. So ultimately, the legislation was drafted to provide a framework for the courts to interpret ambiguous cases, leaving room for judicial discretion when addressing law situations. And the criminal sanctions therefore reflects the government's determination to eliminate any form of commercial surrogacy and ensure the service arrangements are based on altruistic motives rather than financial gain. And one of the distinctive features of Hong Kong's surrogacy law is its extraterritorial reach, which ensures that the prohibitions on commercial surrogacy extend beyond Hong Kong. So this section 16 and 17 of the HRTO expressly use the language whether in Hong Kong or elsewhere. And this means that any Hong Kong resident involved in the commercial service arrangement, even if the arrangement takes place outside of Hong Kong, may still be subject to criminal penalties under Hong Kong law. And the intent was clear. Even if the service arrangement occurs in a country where commercial service is illegal, Hong Kong residents are still bound by the prohibitions of their home jurisdiction. But despite the clear legislative intent, the enforcement of such extraterritorial laws is as of now, there have been no known prosecutions under the extraterritorial provisions of the Charter. However, in high-profile cases, such as the case of Peter Lee in 2010, the government reiterated its commitment to investigating and prosecuting violations of these provisions, even if the legal actions taken abroad. And just to give you background, Peter Lee is a prominent businessman in Hong Kong and was reported to have hired a California-based surrogate mother to give birth to triplet sons. And he was single at the time of such commercial service arrangement. This had been referred to police in Hong Kong, but was eventually closed for lack of evidence and no prosecution was done. This did prompt a question in the Legislative Council, and legislators asked the Secretary for Food and Health to clarify whether the HRTO's prohibitions apply to Peter Lee's case and if the government will take an enforcement action. And in response, the Secretary, Dr. Shaw, confirmed that extraterritorial application of Section 16 and 17 of the HRTO, which explicitly prohibits Hong Kong residents from participating in commercial service arrangements regardless of their arrangements. And the floor to Daisy for the section. Thank you.
Thanks, Yuxin. So I'm going to talk now about acquiring parenthood in Hong Kong. So similar to the other jurisdictions that we've heard about yesterday, parenthood that has already been assigned in other jurisdictions is not automatically recognized in Hong Kong, and a parental order needs to be obtained under Section 12 of the Parent and Child Ordinance. The requirements for the parental order are largely similar to the UK, which you heard about from Zaina yesterday. So I'd like to focus instead on how the courts have responded to the question of whether parental orders should be granted if there's been a violation of a criminal prohibition. So we have cases on sections 14 and 17 of the HRTO, which, as Yuxin has described just now, prohibit donated gametes and surrogacy arrangements negotiated on a commercial basis, respectively. And in relation to section 14, which is the donated gametes, it should be first noted that while the use of donated gametes is prohibited under the HRTO, the relevant section under the Parent and Child Ordinance only requires that gametes from one of the commissioning parents be used. So that means the other one can be donated. So in cases involving donor gametes, the courts have remained silent on the section 14 prohibition on donated gametes and have simply applied section 12 of the Parent and Child Ordinance without mentioning the HRTO prohibition. So for example, in the recent case of A&E, the commissioning mother had employed the services of an egg donor, but because the sperm of the commissioning father had been used, the court was satisfied that the relevant section under the Parent-Child Ordinance had been met and didn't go further to mention or raise issues under the HRTO. So there are many more cases on section 17, in particular in relation to the section 12 requirement here on the slide about expenses. So this also looks like the one from the UK.
So the first question is whether or not the expenses are reasonable. And whether or not they are reasonably incurred depends on the specific circumstances of the case. And the court has said that in answering this question, the court shouldn't just look at the payments that are made to the surrogate mother, but also at the wider picture and the circumstances in which the payments were made, including payments to agencies. So what is reasonable in a particular case is a question of fact. The amount could vary greatly from one place to another, depending on where the surrogacy arrangement took place. So in terms of retrospective approval and whether that will be granted, Mr. Justice Headley's three-step test in the UK case of Re-X and another was adopted in the Hong Kong case of FH and WB, where the commissioning parents had twins via a surrogacy arrangement in California using a payment in the sum of about $62,500 US. So the three steps of the test follow the UK test as follows: was the sum paid disproportionate to the reasonable expenses, were the applicants acting in good faith and without moral taint in their dealings with the surrogate mother, were the applicants party to any attempt to defraud the authorities. And on the facts of that case, the court approved the expenses on the basis that the commissioning parents had acted in good faith and without moral taint. They hadn't made any attempt to defraud the authorities, and there had been no abuse of public policy. The court also noted that given this was the first case in Hong Kong where the reasonableness of expenses had been assessed, the commissioning parents would have had no precedent authority to guide their understanding of how the court would view how reasonableness would be assessed. So that was one consideration as well. Additionally, the court considered the violation of Section 17 on the negotiation on a commercial basis. Although the prosecution was time barred because 6 months had already passed since the payments were made, and this is something Azan also mentioned yesterday, counsel in the case asked the judge to read down Section 17 so that, among other things, its extraterritorial effect would be removed. Although the judge refused to do this, stating that it should be left to a more appropriate case in the future, she did note that any penal sanctions that the HRTO might impose are plainly not targeted at the child, but at adult perpetrators. And she reaffirmed that the child's rights under the PCO and fundamental rights remain unaffected when one considers the best interests of the child to be of paramount importance. So more recently, we had a case this year in which, although a parental order was granted in the end, the judge did make some important comments about the way forward, which we've included here on the slide. So after reaffirming Hong Kong's prohibition on commercial surrogacy arrangements, both in the law and in policy, the judge commented on what she felt was a worrying trend that commissioning parents seem to be increasingly entering into surrogacy arrangements in jurisdictions that they have no connections with or have no knowledge about. So previously, like in the case of FH and WB, commissioning parents had done the surrogacy arrangements in jurisdictions where they had lived or they had spent time and knew something about. But for example, in this case, CS and SW, the surrogate was in Cambodia and was herself Thai. And the court found that there was a breach of law, not only in Hong Kong, but also the two other jurisdictions of Cambodia and Thai as well. So there was a breach of law in 3 jurisdictions. And on that basis, the judge remarked that this case should be seen as a serious warning to other parents who are thinking about going down this path. And in particular, she noted that in the future, the court would have to be satisfied on a number of matters. So some of these matters include they have to explain why they didn't enter into the surrogacy arrangement in Hong Kong. What kind of due diligence did they do to ascertain that the law on surrogacy is not breached in this particular case? Why did they enter into the surrogacy arrangement outside of Hong Kong? And what due diligence did they do to ascertain the law in those foreign jurisdictions and satisfy themselves that it was lawful there? And it's not likely to be satisfactory for them simply to rely on a surrogacy agency and say that the agency said that that was legal. And this is especially so when there are 2 or 3 jurisdictions involved, as in the current case. So also, who in law are the parents of the child born out of surrogacy? The judge reiterated that the law governing commercial surrogacy and parentage are 2 different matters. So it's not enough to know the law on surrogacy, but you also need to know the law on parentage and what steps have been taken to remove the parental rights of those parents. And if no steps have been taken, why not? Now, of course, it's difficult to see a case in which the courts would actually refuse to grant a parental order, even if these questions weren't answered satisfactorily, given the severely harmful impact that this would have on the commissioned children.
So if expenses are generally likely to be approved retrospectively, then what about prior authorization? And the case of LH and LW has answered this question. So while the court concluded that it did have the power to authorize expenses in advance, the judge disagreed with counsel that the test would be the same as the test for retrospective approval. And instead, you can see here on the slide the list of questions that should be considered for the test of prior authorization. And on the facts of this case, the intended surrogacy agreement would be illegal under Hong Kong law. So the first question here. Because of its contravention of Section 17 of negotiating commercial arrangements on a surrogacy arrangements on a commercial basis, sorry. And because of this, the court viewed it as futile exercise to consider authorizing projected expenses, because that would in effect be condoning an illegal agreement, and accordingly the prior authorization was not granted. So for custody, the question here is this: if legal parenthood cannot be obtained via a parental order by one or both of the commissioning parents, can these parents then acquire parental responsibility or custody for the children, or make alternative arrangements for the children to live with them? And cases in Hong Kong have shown that where parental order is not granted, commissioning parents may alternatively be able to acquire care and control of and access to the children. So for example, in S and J, where the commissioning parents commissioned 2 children by surrogacy arrangements during their marriage, but did not seek to obtain parenthood until the time they commenced divorce proceedings, the commissioning father applied for a parental order under Section 12, but the commissioning mother did not consent to the order being made. And because the section expressly stipulates that the parental order must be made by a husband and the wife, the parental order in this case was denied on the basis that the application made by a single applicant was incompetent, and consequently the surrogate children were made wards of the court pending better arrangements, but care and control was given to the wife with access to the husband. And in the more recent case of HC, formerly known as HWH and WYH, the commissioning parents entered into a contract for 2 children born through commercial surrogacy, again did not apply for a parental order before the marriage broke down. The family court faced challenges deciding over the children's legal status and their jurisdiction to make custody orders in the absence of a parental order. So the case was then passed on to the court of first instance, where the judge ruled that the Hong Kong courts do have jurisdiction to make orders regarding custody and education, so long as the child has been treated by the commissioning parents as a child of the family. So that's the term that they used. And in the decision, the court made it clear that children born under surrogacy arrangements could be considered a child of the family under the Matrimonial Proceedings and Property Ordinance, and explicitly stated that there's no requirement for a parental or adoption order or a sanction of a surrogacy arrangement to be obtained before the child is considered to fall within this definition. So as such, we can see that even where there's no parental order, there have been situations in which parental responsibility and or care and control have been granted. And this is in line with the idea that the best interests of the child are paramount. So that brings us to our last slide. We'd just like to end with some concluding thoughts here. So the topic of surrogacy has recently become rather a hot topic in Hong Kong due to the government's initiatives to boost fertility, with multiple voices in society calling for the relaxation of prohibitions. Given that the last legislative exercise for the HRTO was back in 2000, there is a need to reassess the social consensus today. As often the government says, well, this is the consensus of society, this is why we're doing this, but the consensus was back in 2000. So now it's 2024, we need to look at what the social consensus is today. In addition, we need to consider the practicality and efficacy of criminalizing surrogacy in Hong Kong. If parental orders are being granted in most cases, even where criminal prohibitions are violated, how effective are these measures? And more broadly and more importantly, is criminalizing surrogacy normatively desirable at all? So we might want to go back to some of the points that Molly made in her presentation yesterday morning in thinking about this question. So thank you so much for your time. Here's how to reach us if you have any questions or comments for us after Q&A today. Thank you.
And then we have Dr. Kuek, Cheng from Malaysia. Hi, very good morning to everyone. First of all, I'd like to thank the organizing committee of this conference for a very wonderful conference. And also I want to thank Jens, Lindsay, and also Vince for the opportunity here for me to present here. Now, today I would like to share with you about this surrogacy relation between provision on Muslim and legal ambiguity. Let me start by introducing our country. So Malaysia, as you can see from the map here, it actually comprises West and East Malaysia. So West Malaysia, you can see there are 11 states there, states of Malaya. And at the East Malaysia, you have 2 states. It's called Borneo states, comprising Sabah and Sarawak. And we have 3 federal territories, which are Kuala Lumpur, Terengganu, and also Labuan. Now, Malaysia is basically a Muslim majority country with 63.2% of the population professing, 63.5% of the population professing Islam. And we also have a very unique legal system because it's a dual secular and Islamic law legal system operating concurrently in parallel. And also, in terms of this legislative body, we have at the federal level, Parliament will enact those laws on matters listed in the federal list and also concurrent list in the federal constitution. So among these matters will include health matters and also criminal law. And at the state level, we have state legislative assembly, which can enact those laws on matters listed down in state list and also concurrent list. And this matter will include those Islamic personal law, family law, inheritance law, and also offences by Muslim against the precepts of Islam. So this will actually later will be involved this surrogacy. Now, we also have civil and also Sharia court running parallelly. Okay, now since I said that we have actually a dual secular and also Islamic system, so I'll actually discuss the surrogacy under civil secular legal system. There is actually no federal legislation governing assisted reproductive technology in Malaysia generally. And there's of course also no specific law on surrogacy. Now, however, we have this Malaysian Medical Council that issued a guideline on assisted reproduction, which interestingly has one clause on surrogacy, but it was unclear. Why it was unclear? Because it said that surrogacy is not acceptable to most of the major religions in Malaysia, and surrogacy can potentially lead to many legal dilemmas, and it's not there. It didn't say that it is unethical or it is prohibited. It just said that it can actually lead to legal dilemmas, is not acceptable to majority of the religion to start. So you can see that it's actually unclear. However, there is another clause, which is a general clause on prohibited or unethical practice, which we may actually, again, open to debate on whether this clause prohibits or has the effect of prohibits this surrogacy. So this clause is actually clause 15, which lists down certain practices which is considered as unethical or prohibited. And I will actually list to you those relevant ones. So one of them is developing the embryos for purposes other than their use in an assisted reproductive technology program. The second one is commercial trading in gametes. And the third one, use of assisted reproductive technology in unmarried couples. So if you read these clauses together, it seems that traditional surrogacy, if it is performed commercially, it may be prohibited or is actually considered as unethical, because this can be interpreted as amounting to commercial trading of gametes. If this surrogate mother actually offer herself and actually perform this traditional surrogacy commercially. So this is really construed as actually prohibited. Now, another one is because it says that assisted reproductive technology can only be offered to married couple. So that means that even if you want to perform surrogacy, this is not available for a gay couple or single person. Now, when we talk about offering assisted reproductive technology only to married couple, so does it mean that if it's actually interpreted narrowly, all participating parties must be married couple? Again, this is a problem because the surrogate mother will not have any marital relationship with the intending father. So if we actually interpret the clause narrowly, it is actually surrogacy will not be allowed. But assuming you interpret broadly, that means that as long as this couple which actually requests for the surrogacy service is married couple, and this surrogate mother's role is actually third party, right? Okay, it is maybe, right? Okay, you can actually interpret it, we can interpret it as possibly surrogacy, certain form of surrogacy may be allowed, because even though this is a reproduction involving third party, we have a clause on egg donation in the same guideline. And again, there's no express provision to prohibit egg donation. On the clause of egg donation, they only say they're subject to the, again, this clause 15, the prohibited or ethical factors. So it's no express prohibition on egg donation on the ground that is a third party reproduction. So if you use this analogy, surrogacy may not be prohibited just because it is a third party. So again, you can see that whether surrogacy, at least for gestational surrogacy, whether it's allowed or not, it is not so clear. But traditional, the one is likely to be caught by this prohibited practice clause, right? Okay, if it's performed commercially. So anyway, talking about this MMC guideline, it does not have any force of law. So at the most, if there's any non-compliance by the medical practitioner, it will actually lead to disciplinary action if there's any written complaint lodged. Again, that means that if nobody lodged any written complaint, no action will be taken against the medical practitioner. So that is actually as far as this surrogacy under the civil secular legal system. Now we come to this. This is even more complicated but interesting. Right? This is a criminalization of surrogacy under the Islamic legal system. So just we said that there is no federal law governing surrogacy, but at the state level, we can actually enact law relating to Islamic law. So there is a surrogacy may be criminalized in certain states in Malaysia. Just now I mentioned that Malaysia has 13 states, right? Okay, now, so which state, the state government, we can actually enact the law on Islamic law. So surrogacy may be criminalized by how? Right? By way of this state level enactment on Islamic law and also fatwa. Okay, now what is fatwa? Fatwa is religious ruling as a matter of Islamic matter on a new case or something controversial, something unsettled, which is not directly dealt with by Quran or Hadith, that means the tradition of the Prophet. So something new. So they need this Islamic scholar to actually to answer the question whether this is allowed or not allowed. So it's actually in a question and answer form. So that is actually fatwa. So this fatwa itself, in order for it to be binding on Muslim, on these states, we need to actually have it gazetted. So that means that if it's not gazetted, it's not binding on the Muslim yet. So now we have an interesting situation like this. We have the 3 federal territories and also a total of 5 states issue the fatwa. And the fatwa actually said that it is prohibited to use the service of surrogate mother because this will actually cause confusion to the lineage of the blood kinship. Right. Now, out of these federal territories and also the 5 states, federal territories and 3 states actually gazetted the fatwa. That means that fatwa which prohibit the surrogacy is binding on Muslims who are residing in the federal territories or the 3 states there. The 3 states are Pahang, Selangor, Kedah. The other 2 states which also issue the fatwa didn't gazette it. That means that the fatwa is not binding in these 2 states. And even more complicated that another 8 states, right, because we have 13 states, the 8 states didn't issue any fatwa. So basically you have a situation here. Federal territory with plus 3 states which have gazetted fatwa,
So this one, surrogacy is criminalized in all these places for Muslims who are residing there. Then you have two states which have fatwa but not binding because there's no gazette, and also 8 states which do not have the fatwa. So of course there's no nothing binding on them. So that means that these states which do not have fatwa and also those fatwa which are not gazetted, those states with fatwa not gazetted, basically nothing can be done if surrogacy is actually performed by Muslim. So you can see that there's actually lack of uniformity even among this, the way it was actually on Muslim residing in different places. Now, so how is it actually it will fall under the offence? Because under the Sharia offence enactment of these states and also the federal territories, it was actually, there are 2 sections which are actually particularly important. The first one is, they say that acting in contempt of religious authorities, disobeying Mufti is actually Islamic scholar which issued a fatwa. Given by fatwa, that means that you disobey this Mufti to this disobedience to the fatwa, right? So the other provision, also an offence, is you try to propagate, you try to disseminate an opinion which is relating to Islamic law contrary to the fatwa. So all these offences, these are 2 separate offences, but they carry the same sentence. So if actually found guilty, all right, the person can be fined for not exceeding 3,000 ringgit, or imprisonment not exceeding 2 years or both, right? Okay. So now you can see that who are the potential offenders then. Since we said acting in contempt of religious authority, right, against not respecting or not doing this Mufti fatwa. So this can be those Muslim who actually perform this surrogacy. It means that maybe the surrogate mother, the intended parents, because acting in contempt of this religious authority by way of not obeying the fatwa. Because the wording of the fatwa is use of surrogacy service. So we can't really actually get this medical professional to fall under this, but medical professional and also agency may fall under the other position, which is propagating, disseminating an opinion which is relating to Islamic law contrary to fatwa. So they may, the agency, if they actually advertise the surrogacy service, for example, or maybe the medical professional, if it's a Muslim, right, residing in those states, they may be caught if they actually perform surrogacy, if they provide any opinion encouraging the patient, for example, to undertake this. So basically, all these provisions is only binding on Muslim residing on the federal territories and also the 3 states, Pahang, Selangor, Kedah only. So it doesn't apply to other Muslim in other parts of Malaysia, residing in other parts of Malaysia. It also does not apply to non-Muslim because non-Muslim are not governed by the Sharia law. So you can see the complication here, right? Okay, now, next. Just like we said that, well, it's actually debatable as far as non-Muslims is concerned, depending on how you actually interpret just now the clause 15 of the MNC guideline on assisted reproduction, whether surrogacy is prohibited. At least I'm talking about this subject, gestational surrogacy. So now, assuming we give a scenario like this, the commissioning parents are Malaysian non-Muslim, and they actually engage this surrogate mother, also a Malaysian non-Muslim. So we have one provision which is important, Section 112 of the Evidence Act, which create the legal presumption that the person is a legitimate child of a man if the child is born during the valid marriage between this man and his mother. That means that if a child is born by way of surrogacy, he will be the legitimate child of the surrogate mother and also the surrogate mother's husband. So there's how to make it as a legal child of his commissioning parents. The only way is actually by way of adoption. So next, if let's say foreigners coming to Malaysia, but they are not residing in Malaysia, right? Okay, so they are non-Muslim, and you actually get a surrogate mother who's a Malaysian non-Muslim there. Again, if you look at the Evidence Act, because the child is born with this Malaysian non-Muslim, so under the Section 112 of the Evidence Act, is presumed to be legitimate child with the surrogate mother and also her husband. So how to make the child as legitimate child or legal child of this conventional parents? So again, by adoption. So we can actually refer to the law of their home country on this adoption. But if they are foreigners who are already residing in Malaysia, but of course maybe not known for permanent, so but they fulfill the requirement of residence or that, it is also possible to adopt under the Malaysian Adoption Act. Now, we come to another third scenario. Now, let's say Malaysian non-Muslim, they go overseas to get overseas surrogate mother, right, to perform this surrogacy. So now, of course, they have extra challenges here because they have to adopt the child. One thing, they have to adopt the child, and this is provided the child also must have this valid travel document, because when they want to adopt, they need to actually fulfill some requirement of the residence, including the child must actually residence in Malaysia for some time. So for a required period, so we need to ensure that the child have the proper traveling document to enter Malaysia or that. But even if they are successful in obtaining this adoption of the child's citizenship is not Malaysia yet. So they actually have to make another application to obtain this Malaysian citizenship. And they need to fulfill again those special circumstances or that hardship where the registry will actually look at the hardship, is any hardship or not, and best interest of the child. So it is actually extra hurdles for them. So two levels like adoption and also Malaysia citizen, because the adoption didn't come automatically with the citizenship. Of course, all this I'm talking about non-Muslim level. And not Muslim, because we already know that for Muslim, this is actually prohibited, criminalized on those states. And for other states, even though it's not criminalized, normally for Malaysians, if actually they know that this is prohibited by the religion, they will be quite reluctant to perform it. Even though there's no legally enforceable law, it's a religious duty, they will tend to not to perform, including this, those Muslim medical professionals. So if nobody willing to perform it, nobody willing to actually get this service or that, so it can hardly happen to this Muslim. But assuming we just take a possible or theoretical assumption that there's Malaysian parents are non-Muslim, are Muslim, Malaysian Muslim, we actually get surrogate Malaysian Muslim to perform it, the child will actually be considered as illegitimate child, because under the Muslim law, they actually regard this child is not from the husband and wife, the married couple, but is actually from third party, and this is not allowed. So the child will be illegitimate. And unfortunately, there's no way they can actually use the adoption law to adopt the child legally, to change the legal status of the child, because the Adoption Act is only applicable to non-Muslim but not the Muslim. At the most, let's say the commissioning parents have in possession of this child, the surrogate child, they can only register the child under this de facto adoption. But this de facto adoption, even if you registered under the law, it didn't change the legal status of the child. It's still not, it would not change the status of the child to be the legal child or legitimate child of the commissioning parents. They will still remain the status. Nothing will change about biological status and also legal status, because Islamic law is very strict on this lineage and also how the property is going to be distributed, because it is actually not the legal child of this family, basically he can't get all this inheritance right of this commissioning parents. So you can see the complication there, right? Okay, now, so no legal adoption is allowed. So
Anyway, talking about efficacy, there's no reported case in Malaysia about any Muslim being charged, even though I mean, in certain states, there actually criminalization of surrogacy. There's no Muslim being charged on that. And also, there's no reported case of any medical practitioners that there's any disciplinary action being taken. So this could be probably because surrogacy is relatively rare in Malaysia, people don't do it openly or advertise it openly. So basically, in my conclusion, actually 10 years ago, in 2015, Malaysia actually tried to propose, tried to draft a bill called Artificial Reproduction in Tissue Bill, to govern this assisted reproductive technology. However, it was never tabled, so we actually have no chance to see the bill. So we are not sure actually how they actually intend. But 10 years have elapsed. There's still no sign that this bill is going to be tabled. So and we also see that probably lack of political will. So legitimacy of surrogacy in Malaysia is basically determined by the religion of the participating parties, and also when the fatwa is actually issued and gazetted. So it's not criminalized non-Muslim. So, but anyway, the emergency guideline is under some review. So it is actually not finalized yet. So whether it's leading to a more liberal position or is actually getting more rigid, this one remains to be seen. Thank you very much.
So I think most of us are back in, so I will make a start for the final geographical panel of the conference. My name is Spencer Clark. At the moment, I jointly head up the Property, Family and Trust team of the Law Commission of England and Wales. As you can see today, I'm speaking rather than sitting as a silent partner on the panel. So we have a wonderful panel of speakers today. On my far left is Professor Corny Joslin, who is the Martin Luther King Jr. Professor of Law at the UC Davis School of Law. And during the fall 24 semester, so this semester, she is also a visiting professor at UC Berkeley School of Law. Professor Joslin is a leading US expert in the areas of family and relationship recognition and has a particular focus on same-sex and unmarried couples, and is currently working on an empirical project exploring functional and social parent doctrines in the United States. Next to her, we have Professor Claire Fenton-Glynn, who is a professor of law at the University of Monash, Australia, in Melbourne. She was previously the professor of child and family law at the University of Cambridge and director of Cambridge Family Law. And then last but not least, we have Professor Deborah Wilson, who is Professor of Medical and Criminal Law at the University of Canterbury, New Zealand. Her main research interest is in the law relating to assisted reproduction, and she has published widely in the area. She is currently the lay member with expertise in law for the Advisory Committee on Assisted Reproductive Technology, or ACART, which writes policy for assisted reproductive technology in New Zealand. So over to you, Professor Joslin.
Oh, there we go. Okay, great. Thank you. Thank you. And at the risk of sounding repetitive, I wanted to also extend my thanks to Yen, Selena, to Daisy, and everyone else who helped make this really important conversation possible. And thanks for having me. So in addition to teaching and writing legal scholarship in the area of family law and on parentage issues specifically, I'm also engaged in law reform efforts in the United States. So most relevant to our conversation today, I was the reporter, the drafter for the Uniform Parentage Act in the United States, UPA of 2017, which is a model state statutory scheme promulgated by the United States Uniform Law Commission governing children's legal parentage. And it includes provisions related to surrogacy. So Article 8 of the UPA permits and regulates both gestational surrogacy and traditional, or what we call genetic surrogacy, and it also allows for compensation. To be clear, not all US states have laws based on the UPA of 2017, but it has proven quite influential. There are currently 9 states in the United States that have surrogacy provisions based on Article 8 of the UPA. And so for this reason, during my remarks, I will refer at times to the Uniform Parentage Act. And then I guess just to orient us to US law, as my comments that I made just suggested, in the US, parentage law is governed by state law. There is no federal law governing children's legal parentage. And so that means in the US, we do not have a single law of surrogacy. We have 51 jurisdictions that have or may have law on surrogacy. And so my goal is to try to give us a sense of trends that we're seeing in the United States. And in terms of what the law is, we are seeing, there are still some US states that have no statutory law on surrogacy, but the strong trend in the United States is in favor of the enactment of statutes that permit and regulate at least some forms of surrogacy. So we now have 31 states, jurisdictions that have some kind of statutory law governing surrogacy, and 27 of the 31 jurisdictions have laws that permit and regulate surrogacy in at least some circumstances. And here's just a different visual representation of the map. The red variations are states with some sort of ban, and the blues and the greens are states that have permissive schemes. And to sort of drill down on the states with bans, the very few states that we still have that have bans, we have one remaining state. The state of Michigan is the only state that still has a broad criminal ban on surrogacy. The law that was enacted in 1988 imposes criminal penalties on compensated surrogacy arrangements, and the penalties there can be imposed both on the participants, so the surrogate and the intended parents, as well as on third parties who arrange or otherwise assist in the arrangement. And the law also civilly bans surrogacy arrangements and provides that they are void and unenforceable. But to be clear, Michigan repealed this law earlier this year in 2024, and the repeal will go into effect likely in early 2025. And when they repealed the law, they replaced it with a scheme that permits and regulates both gestational and genetic surrogacy arrangements and allows for compensation for both types of arrangements. And then we have a few jurisdictions that have more limited types of criminal bans. So, for example, New York in 2021 repealed its broad criminal ban, replaced it with a law that now permits and regulates gestational surrogacy, including compensated gestational surrogacy, but it retained its criminal ban on compensated genetic surrogacy arrangements. And there it imposes possible criminal penalties on third parties that facilitate compensated genetic surrogacy arrangements and allows for civil penalties on the participants themselves. And then we have one other state that falls in this category. Virginia permits gestational agreements, some genetic surrogacy arrangements, but does have a pretty narrow criminal ban that imposes a misdemeanor crime on third parties to accept compensation for recruiting surrogates and for inducing intended parents to enter into surrogacy arrangements. But once the Michigan ban, the broad criminal ban in Michigan, is repealed, there will be only 4 states remaining with broad civil bans. 2 states civilly ban both compensated and uncompensated gestational and genetic agreements. And then 2 other states have more narrow civil bans, civilly banning just compensated surrogacy arrangements. And in terms of prosecutions, so we have very few states that have any kind of criminal prohibition on surrogacy. And I'm not aware of any criminal prosecution in the United States for people based on violations of surrogacy-specific criminal statutes. There have been some arrests and convictions of attorneys and other third parties who have been engaged in fraudulent behavior that was related to surrogacy, but they were charged under other general criminal statutes, generally fraud statutes. So just to give a concrete example, there was a man who was convicted on federal criminal charges for defrauding many individuals by using funds that he had agreed to put in an escrow account for the surrogacy arrangement and then using the funds for himself. But again, not a conviction under a surrogacy specific provision. So we, again, very few states with bans. The very strong trend is in favor of the enactment of statutes that permit and regulate at least some types of surrogacy arrangements. And a number of states that fall in this category are jurisdictions that used to have broad criminal bans and have since repealed them. So DC repealed its criminal ban in 2017, Washington repealed its criminal ban in 2018, New York in 2020, and then Michigan earlier this year. And then in terms of the states that permit and regulate surrogacy, I do think it's interesting to note that in the United States, it really spans the political spectrum. So of the recently enacted statutes, there are some that were enacted in, what in the United States we would call deeply blue states, very progressive states like Massachusetts and Connecticut. But we also have states that have recently enacted permissive schemes that are what we would call deeply, deeply red states. So that includes Idaho, Wyoming, and Oklahoma are states that have recently enacted permissive schemes. And I think there's a number of reasons why we have seen this pretty strong shift in the United States away from bans to statutes that permit and regulate surrogacy. I think, one is one that we've heard, I think, quite repeatedly over the last 2 days, which is that criminal bans do not bring an end to the practice of surrogacy. So this was a news story around the time that Michigan enacted its recent statutory scheme, repealing the ban, replacing it with a permissive scheme. And, as the story made clear, there were families in Michigan, despite the existence of the criminal ban, that were engaged in surrogacy. Some of them traveled to other states, engaged with surrogates that were residents of other states that permitted surrogacy. Some found ways to comply with the statute within the state. And likely some people just continued to engage in surrogacy in the state in violation of the statute and did not face any penalties. And then I think what also became clear when Michigan was considering this recent legislative enactment, and I think is also something that we have heard over the past 2 days, is that it became more clear that the most poignant impact of the criminal ban was really to leave the parties, including the person acting as a surrogate and certainly the child, legally vulnerable. So, for the intended parents, for example, in Michigan, many of them reported that they had to wait years to establish their legal parentage to their child. As a result, they had to live in uncertainty and legal limbo with regard to their relationship with their child. Not surprisingly, this adds stress to people's lives during a period when it is stressful to be a parent of a young child. In the United States in particular, if someone is not recognized as a legal parent, it can impede their ability to care for their child. It can make it difficult for them to provide health insurance to the child. It can make it difficult for them to make medical decisions for the child, to provide financial benefits for the child. And so there were very real concrete impacts on the child. And then also for the people acting as surrogates, in a state where there is a broad criminal ban, one of the effects is that there is no legal protection provided to them in the state, no minimum protections that need to be included in the agreement. They might fear even going to court to seek protection if they are experiencing some kind of coercion or there has been a breach of the agreement, for fear that they could get in trouble themselves. And in addition, I think, especially in the United States today, where am I going? In the United States today, there is an assault on reproductive autonomy. And I think some of the folks who have been working in favor of statutes that permit and regulate surrogacy see these schemes as protective of reproductive autonomy, protective of the rights of the intended parents to make decisions about when and how to form families. And some view them also as protective of the reproductive autonomy of people acting as surrogates to make decisions about what to do with their bodies. So again, we have a very strong trend in favor of statutes that permit and regulate surrogacy. And in these states, there is an increasing trend to include basic safeguards and protections in the statutes to ensure that the agreement is considered to be compliant. And I think some states have concluded if that's what the goal is, to provide protection for the participants, including the person acting as a surrogate, that the most effective or the more effective way of ensuring that those basic safeguards and protections are included is to pass a permissive scheme that includes basic safeguards in it. And so in terms of common safeguards that we're seeing in statutes, these are requirements in the UPA. Again, these requirements are not in place in all jurisdictions, but we are seeing an increasing number of states that include these basic safeguards. So a common requirement is that all of the participants be at least 21, that they have completed a mental health evaluation. Another common requirement that we are seeing states include is a requirement that all parties be represented by separate independent legal counsel through the duration of the agreement regarding the terms of the agreement. And I guess I was struck yesterday by the fact that some jurisdictions have passed statutes criminalizing the engagement of lawyers in the process. And that is very contrary to the conclusion that we have reached in the United States. In the United States, again, a key safeguard that many states have decided to include, again, is the provision and the requirement of independent legal counsel to ensure that all of the parties understand the terms of the agreement and that all of the parties have an advocate that is looking out for their best interest in the creation of that agreement. And some other basic safeguards that are commonly included that are specific to the person acting as a surrogate. So a number of states require the intended parents to pay for the counsel for the person acting as a surrogate. A number of states, based on the UPA of 2017, require the agreement to permit the surrogate to make all health and welfare decisions regarding herself, her body, and the pregnancy. To be clear, this is not the law in all jurisdictions. There are some US jurisdictions that have statutory schemes that allow the agreement to include clauses that require the person acting as a surrogate to undergo recommended treatments, even if it is against her will. But again, there is a trend in favor of requiring the agreement to allow her to make all of those health and welfare decisions. And under the UPA, if there is such a clause that does not allow her to make all health and welfare decisions, those clauses are void, and the inclusion of those clauses could render the agreement to be non-compliant, which has potential legal consequences. And then another very common requirement in the United States or provision in the United States is to allow for the provision of compensation. And I guess what I would say here, certainly, I think this is maybe the point at which we depart the most from the other countries represented here. And I guess I'll just add some of the reasons why states have reached this conclusion that to allow for the provision of compensation. I think one reason is that many states, many policymakers have reached the conclusion that people acting as surrogates are literally performing labor. They are performing labor. This labor is risky. It potentially creates health consequences for them, not just during the pregnancy, but potentially for the rest of their lives, and that they should be able to be compensated for engaging in that labor. I think some also argue that rules that permit surrogacy but prohibit compensation perpetuate stereotypes about women's labor, that women's domestic labor is expected and that is not worthy of compensation. And then, I think also the decision of many states to allow for compensation also reflects the fact that even in the jurisdictions that don't allow compensation in the United States, and there are very few of them, just 2 states don't allow for compensation. Even in those jurisdictions, some forms of reimbursement is permitted. And so in all of the jurisdictions that permit surrogacy, some exchange of money is permitted in those jurisdictions. And so, and some reach the conclusion that, again, if compensation is prohibited even when the state allows for surrogacy, the practical effect of not allowing compensation can be actually to diminish the bargaining power of the person acting as a surrogate and to leave her actually more rather than less vulnerable. In terms of the types of surrogacy that are permitted in the United States, here we do see a split. So we currently have 15 states that permit just gestational surrogacy in a variety of circumstances. Here we have seen a pretty recent shift. More and more states in the United States are now permitting and regulating both gestational and genetic surrogacy. That's a very, very recent shift. And here, just to be clear, some of the jurisdictions that permit both types of surrogacy do treat them differently in some respects. So some of these states have additional safeguards and requirements that are imposed on genetic surrogacy arrangements. Although in 2 jurisdictions, they are treated absolutely identically, there are no differences. And here, I think in terms of the shift in favor of permitting both types of surrogacy, I think there are a number of reasons why we've seen this shift. One, I think, is that initially there was an intuition of some that when people engage in genetic surrogacy, that the genetic surrogate might be more likely to regret her decision. There might be more likely to be problems in genetic surrogacy arrangements. And I think we've seen a number of social science studies that have dispelled those intuitions. And so I think that's one of the reasons for the shift. And then I think there also has been a greater appreciation in the United States that if only gestational surrogacy is permitted, that necessarily means that the person acting as a surrogate is subjecting herself to greater health risks because it means that she must undergo an embryo transfer. Whereas if you are engaging in genetic surrogacy, there is no need for an embryo transfer. And so it potentially reduces the health risks imposed on the person acting as a surrogate. It can reduce costs to some degree because, again, you don't have to engage in an embryo transfer. And so, again, for this reason, we have seen a very, very recent shift in favor of more states permitting also genetic surrogacy. And then in terms of parentage, on the issue of parentage, generally speaking, in the states that permit and regulate surrogacy, where the parties have complied with all of the requirements set forth in the statute, both intended parents are generally recognized as legal parents of the child without the need for an adoption. In some US states, under at least some circumstances, the state law does require them to go to court once, possibly twice, actually, in order to be recognized as a legal parent. But by contrast, in a growing number of jurisdictions in the United States, if the parties have complied with all of the statutory requirements, the intended parents will be recognized as legal parents by operation of law. And in theory, they don't have to go to court at all. To be clear, in these jurisdictions, the automatic recognition of the legal parents, of the intended parents as the legal parents, again, only applies if they have complied with the requirements set forth in the statute. With regard to non-compliant agreements, I would say these states generally take a position that is different than Ireland, where Ireland, as we learned yesterday, takes the position if it's not compliant, the intended parents will not be recognized. And I think the US states have reached a different conclusion about how to incentivize the behavior that they want, but then also what to do when parties haven't engaged in that behavior. So the incentive to comply is that the parents will automatically be recognized as the legal parents. And then if the agreement is not compliant, then it is up to the discretion of the court to declare the parentage of the child. The court has the power, the authority to recognize the legal parents as the intended parents as the legal parents. And often that's what all of the parties want. Often that's where the child has been living. And so often that is in the best interest of the child. But the parties do face legal uncertainty. And so that's the disincentive that is provided for not complying with those requirements. So just to sum up, generally speaking, we're seeing a trend in the United States in favor of enacting statutes that permit and regulate surrogacy. The schemes are increasingly likely to set forth comprehensive requirements and protections for all of the parties, including the person acting as a surrogate. And my expectation is that we will continue to see a growing number of states in this category.
Thank you very much, Courtney. And now over to you, Claire.
Okay, so first of all, I should say this paper was prepared in conjunction with Alexandra Harlan, who unfortunately can't be here today, but has been really influential. She's a judge in Australia, so has a lot of knowledge, particularly about the transfer of parentage, which I'll speak about momentarily. So I have somewhat the same problem as Courtney, though not quite as extreme, in that Australia is a federal jurisdiction. So it's made up of 6 states, 2 territories, each of which have their own legal system. Now, unfortunately, Australia has an additional problem in that state and federal law in relation to parentage both have jurisdiction to a certain extent, and therefore we do have some conflicts. So the allocation of parentage, the registration of birth is largely a matter for states and territories, but there are also some federal law provisions which relate to this matter, and this makes the legislative framework surrounding surrogacy really complex and difficult to navigate. In general, however, surrogacy is regulated on a state level, and it is permitted in all states and territories. They all have a specific legal framework for regulating surrogacy arrangements undertaken within their jurisdictions. These all operate on a pre-birth approval basis, so intended parents apply to the regulatory body prior to conception in order to obtain permission to undertake the surrogacy arrangement, and if this occurs, then legal parenthood of the intended parents can be recognised after birth. However, this will only be granted in common with the majority of jurisdictions if the surrogacy arrangement is altruistic. So it is simply not available to make a parentage order if there is a commercial element to the arrangement. This is for domestic surrogacies. For international surrogacies, there is no such specific legal framework, and they are dealt with under the federal legal system. And this legal system has no equivalent provision to a parentage order that you can find other states. And as a result, the federal courts that exercise family law jurisdiction are forced to come up with other alternatives. So if we're looking at how to classify the Australian regulatory system according to those prohibitive, tolerant, regulatory free market, Australia doesn't quite fit within any. So the domestic surrogacy falls within the regulatory system, whereas in relation to international surrogacy, it's a very much prohibited jurisdiction. So if we turn to the criminal sanctions that we see in relation to surrogacy, the criminal sanctions against the surrogate and intended parents are generally the same in Australia, so I'll cover them together. I've tried to put a lot of information in the slide because there is literally no way I can actually give you all this information orally in 20 minutes. The legislation in all 8 Australian jurisdictions is disparate, but the aim does remain the same: the prevention of commercial surrogacy and the view that it is exploitative of women. Now, there are two kind of camps that jurisdictions fall into. The ones criminalising the remuneration or the commercialisation of surrogacy, and those relating to advertisements. And so I'll deal with each in turn. So we can see for remuneration, all Australian states and territories place criminal sanctions for a surrogate and for the intended parents entering into a commercial surrogacy arrangement. Now, the exact wording differs from jurisdiction to jurisdiction, whether you're looking at entering or offering into, whether it's intentional, all these minor differences, but all really remain the same. The only notable exception here is Victoria. And that is because in Victoria, the criminal sanctions are directed solely towards the surrogate and not the intended parents also. It is the surrogate who must not receive any material benefit, and it is she who is criminally liable if money changes hands. Why? Not so sure. So the explanatory memorandum accompanying the legislation doesn't shed any further light on this. And there was a recent review of this law, which likewise didn't really tell us anything about it. And it's very odd because it is not only at odds with the other Australian jurisdictions, it's odds with international practice, and it is penalising one of the parties that the prohibition of commercial surrogacy is intended to protect. So I'm not entirely clear what's going on there. Nevertheless, that is, be that as it may. So the second criminal sanctions that can be put in place in relation to surrogacy arrangements for intended parents and for surrogates is in relation to publishing willingness to enter into a surrogacy arrangement. Now, I should say all the penalties are down the side, and you can see that these are quite significant. So an Australian dollar is roughly half of an American dollar. So you can see these are pretty significant fines and indeed pretty significant prison sentences also. So we can see in the ACT, that is the Australian Capital Territory, New South Wales, South Australia, Northern Territory, Western Australia, the prohibition against publishing willingness to enter into an agreement only relate to commercial surrogacy arrangements. In Victoria and Queensland, however, the sanctions extend to simply indicating a willingness to act as a surrogate, whether or not you are indicating altruistic, which would be legal under the jurisdictions, or if you're commercial. Interestingly, in New South Wales, the offence only relates to publications for which a fee has been paid, which opens the door for, say, social media, and it leaves surrogates the ability to indicate their willingness through free publications. No other states make such a distinction, but in New South Wales, the maximum penalty that may be imposed differs depending on whether the agreement was commercial or not. It's important to note that in Victoria, as I said, there was a recent review of the law, and they did note that the current prohibition on advertising creates a significant barrier to access for people seeking to have a child by entering into a lawful surrogacy arrangement in Victoria. So they noted that individuals had been threatened with prosecution for publishing their desire to find a surrogate on online forums. And the view of the review was that the needs of people who wish to connect with an altruistic surrogate in Victoria should be met through a more balanced approach to the regulation of advertising environment. Now, that hasn't happened, but at least we can see that they are looking into it. So those are the kind of criminal sanctions that can be imposed against surrogates and against intended parents. When we moved to the field of agents and intermediaries, we can see that the criminal prohibitions fall into three categories. Those relating to negotiation of surrogacy arrangements and the facilitation of surrogacy services. Those relating to the introduction of surrogates and their procurement. And thirdly, relating to advertisement. And you can see that each jurisdiction has a slightly different combination of where they place the emphasis in this respect. So when we look at negotiation or the provision of services, we can see that in two Australian jurisdictions, that is South Australia and Tasmania, it's an offence to negotiate or offer to negotiate a surrogacy agreement on behalf of another for valuable consideration. So this goes against the American model. We are deliberately moving lawyers, moving intermediaries outside of the protection and moving the protection away from surrogates. In Tasmania, the legislation also extends to compiling information with a view to its making or negotiating a surrogacy arrangement. So even a lawyer's office kind of taking the preliminary steps is a criminal offence. In Western Australia and Northern Territory, however, the provisions go further than negotiation and include any provision of services. Now, this is slightly mitigated by the fact that the legislation in Northern Territory explicitly states that it doesn't apply to legal practitioners representing a person seeking legal assistance. And in Western Australia, the explanatory memorandum to the legislation makes a similar point. Nevertheless, we can see that there is a broad intention here to move lawyers and intermediaries out of this space. There are differences between whether or not the prohibition relates to any commercial, any surrogacy arrangement or only commercial. So South Australia, Northern Territory, Tasmania, the negotiation and provision of services extends to any and all relationships. So even the altruistic, completely legal and fully recognised agreements cannot have this intervention. In Western Australia, on the other hand, it's restricted to commercial arrangements. If we then look to procurement and introduction, the Australian Capital Territory is alone in imposing criminal sanctions on a person who procures someone to enter into a surrogacy arrangement. However, closely linked to this, we see the South Australian and Western Australian prohibitions, where it's an offence to introduce people seeking to enter into a surrogacy agreement for valuable consideration. In Queensland, on the other hand, we see that intermediaries are covered by the more general prohibition applying also to surrogates and intended parents. That is a prohibition for receiving payment for another person entering into a surrogacy arrangement. And finally, we have advertisement. So Victoria and New South Wales have very strong prohibitions here. In Victoria, this is the only restrictions in relation to intermediaries. And we see that these prohibitions are very similar to what's going on with intended parents, what's going on with surrogates. So publishing statements, advertisements, notices, documents indicating a willing to enter into surrogacy arrangement or likely to induce someone to enter into. So contrary to these really quite extensive provisions in relation to surrogates, intended parents, and to a certain extent intermediaries, medical and healthcare professionals are not really covered by surrogacy prohibition in Australia. So 4 of the 8 jurisdictions, there are no specific sanctions against medical professionals. However, in the ACT, Northern Territory, Queensland and Western Australia, you see the prohibitions against provision of services and the facilitation of a surrogacy arrangement. These provisions that also apply to intermediaries also apply in relation to providing medical services. The final note I want to make in this respect is in relation to South Australia, which has some innovations which aren't present in the rest of Australia and are not really something that I've seen mentioned over these last couple of days. And this is additional offences relating to the inducement to enter into a surrogacy arrangement. So the first makes it a criminal offence to induce another person to enter into a surrogacy agreement by threat of harm, by dishonesty, or through undue influence. And the second, criminalise a person who, for valuable consideration, induces another to enter into a surrogacy agreement. And both of these are subject to a maximum penalty of 2 years. Now, what's really interesting about the Australian criminal law provisions in relation to commercial surrogacy is that while in the majority of states, they are only applicable within the jurisdiction, in New South Wales, Queensland and the ACT, they do have extraterritorial effect. That is, if you are ordinarily resident or domiciled within the relevant state or territory, you can be criminally liable for any of the offences that I've mentioned above. So in 2023-24, the Australian Capital Territory introduced new legislation on surrogacy arrangements, and as part of this process, it considered whether the extraterritorial application should be obtained. And this was particularly in light of numerous submissions made to the committee reviewing the legislation, that the extension of jurisdiction was ineffective given the fact that there had been no prosecution in this respect. This was firmly rejected by the government and the minister in question. So the minister argued that the fact that there are no prosecutions does not indicate the efficacy of criminal legislation. They said it doesn't tell us the number of people who are being influenced not to engage in commercial surrogacy due to the criminal prohibition. And the government also referred to significant human rights concerns associated with commercial surrogacy, particularly overseas where there might be less protection for the parties, and argued that there was a strong reason for maintaining this prohibition, even for symbolic value. So where intended parents have entered into a surrogacy arrangement permitted within the jurisdictions, that is in an altruistic arrangement that has complied with all the requirements, then they simply seek a parentage order before the relevant state court. Where the intended parents have entered into a surrogacy arrangement that falls outside these laws, either because it's a domestic commercial surrogacy, a domestic surrogacy that doesn't fit within the requirements of the framework, or whether it's an international surrogacy arrangement that has been undertaken commercially, there is no possibility for legal parenthood to be transferred to them in the state or territory, and they have to approach the Australian federal courts holding federal jurisdiction. However, as I said previously, the parentage provisions of the Federal Family Law Act of 1975 were not drafted with surrogacy in mind and are singularly unfit to deal with children born through such arrangements. So while some, though not necessarily all, early cases before the federal courts showed a willingness to make what is known as a declaration of parentage, so applying the ordinary presumptions of parenthood, fatherhood to the biological father, etc. This was only available for men. It wasn't available for intended mothers. And even this avenue for parenthood was closed in 2015 following a decision of the full court of the family court, which held that the court cannot make a declaration of parentage, notwithstanding a biological relationship, if the child has been born as a result of an illegal surrogacy arrangement. And as a result, we see that anyone who has entered into one of these arrangements simply cannot get legal parenthood in Australia. They have been forced to seek other less attractive options. Ones that have been tried is registration of overseas parenting orders, not so much. Adoption has been successfully used, but not consistently. But usually what parents are having to satisfy themselves with is simply parental responsibility. That is that they can have custody of the child, they can have the child live with them, but their legal parenthood will simply not be recognized. If we look at the efficacy of the criminal sanctions, it is hard to conclude as what exactly the efficacy is. When we look at the evidence concerning the extraterritorial application of the laws, as I said previously, no Australian has ever been prosecuted for engaging in commercial surrogacy abroad. And this is despite statistics suggesting that nearly 3,000 children have been born in the last 14 years to overseas surrogacy arrangements. And the Australian Federal House of Representatives Standing Committee on Social Policy and Legal Affairs noted that the evidence suggests that extraterritorial offences have not deterred legal parents, and referred to testimony that they received from numerous parents who had undertaken such a journey. Evidence from individuals who undertook the prohibited practices and received no sanctions does appear compelling. However, we do have to consider the fact that, as the ACT government pointed out, this in and of itself is not determinative. It also doesn't take into account the extent to which this is known, the extent to which that the intended parents or indeed the surrogate have knowledge of the law. And quite simply, there has been no studies taken in this respect. So this is an area where further research is needed, and we really need to get a grasp of this. So where does that leave us? It leaves us with a really complex and fragmented legal framework. And there's a real need in Australia for greater harmonisation between not only the states and territories themselves, but between state and federal jurisdiction. This disparate legal landscape and indeed the real lack of certainty for children born as a result of surrogacy that don't fit within the state regimes leaves surrogates, it leaves intended parents, and particularly it leaves children in a really precarious legal position. And for that reason, both Alex and I really advocate the need for legal reform in Australia in relation to this. So thank you.
Thank you, Claire. And over to you.
Well, the good news is that New Zealand only has one jurisdiction, so this will be pretty quick. I could make it even quicker and just simply say New Zealand has criminal surrogacy laws, but nobody cares, and we could just go to lunch. But I think Jens would probably want his airfares back if I do that. So I'll spend a couple of minutes explaining why we have laws, but nobody cares. So just because I wear a variety of hats when it comes to surrogacy, I'm here as an academic, but I was a member of a group that advised the Law Commission on recent law reform proposals, and I sit on ACART, the advisory committee, which is going to be the committee that writes the guidelines to make the new law work when it comes through next year. So a lot of what I say is coloured by my experience in the law reform and the regulation writing side of things, but I'm here as an academic, so they don't really know I'm here. They kind of do, but they haven't read what I've said. So just to give you a quick overview of surrogacy law in New Zealand, it's regulated, and I use that term really loosely. There are a couple of words that say surrogacy in the Human Assisted Reproductive Technology Act. There's a new bill out, which is quite interesting. It came out 2 days before I had to put the chapter for this project in, so that didn't give me too long to really understand it, but I think that's okay, because having met with the Health Select Committee last week, they don't understand it either, so that's fine. So I'm going to talk about the current law, and anything you see in red is what I think the proposed new bill is going to be about. So in New Zealand, domestic commercial surrogacy is prohibited, although medical and legal expenses can be paid. Under the new bill, reasonable expenses will be allowed to be paid to the surrogate. We have nothing on international surrogacy, no reference to it, so that makes things a bit easier. One of the reasons why I'm so involved in the regulation is that domestic gestational surrogacy in New Zealand, if you want to use a fertility clinic, requires ethics committee approval first. So a fertility clinic who's asked to perform domestic surrogacy has to get permission from the ethics committee first, and the ethics committee considers the application based on guidelines written by the advisory committee, which is me and a couple of other people. Right, so there's that process that has to go through. A child born through surrogacy, adoption is required to formalise that legal relationship, although under the bill, if ECART signs off on the agreement in the future, then parentage will just transfer automatically, provided a declaration is signed by the surrogate a few days after the birth. So in terms of the provisions in the Heart Act that actually do criminalise surrogacy, there are 4. I'd forgotten about one of them, but hearing Claire talk about advertising reminded me that we do have a prohibition on advertising, which I will describe as wonderfully quaint. I'd forgotten about it because it just doesn't work in practice. It says that you cannot advertise in a newspaper for somebody to enter into a surrogacy arrangement. So it's completely pointless because nobody actually takes out advertisements in newspapers anymore. So what people do instead is they go to the newspaper and say, hey, I've got a public interest story. Do you want to hear about my battle with fertility? And the newspapers go, yep, definitely, let's hear about it. So they tell this wonderful, they tell a really horrible story about how they've tried to have a family and it hasn't worked and they're running out of ideas. And surrogacy would be great, but we can't find a surrogate. Absolutely fine.
right? The last person that did that got 40 offers to be a surrogate within about 48 hours, right? As long as they don't use the words, I want a surrogate, would you do it for me? Then it doesn't breach the prohibition and it's absolutely fine. And the provision being written in 1997, it doesn't understand Facebook. And the main source of surrogates in New Zealand, if you don't have a friend or a relative, is by simply going on the Facebook group. And again, the Facebook group is really smart because as soon as you go into the group, it says, do not use the words, would you be my surrogate? So people go on the Facebook group and they tell their story and they're desperate for a family, full stop, post. And then what happens is anyone who's a surrogate in the group that wants to get to know them a little bit better sends them a private message. It's all outside the scope of advertising, so it's absolutely fine. So, you know, advertising is a crime, but who cares? The second source of criminal sanctions is on the fertility clinics and the fertility professionals. So if they want to carry out procedures in relation to surrogacy, they have to get ethics approval first, and it's a criminal offence if they don't. That's a major issue for them because the health professionals will lose their medical licence if they've got this criminal conviction, and the clinic will have to shut down. And given that we've got 2 clinics in New Zealand, that's a bit of an issue. But it's never been an issue in practice because ECART and ACART work really closely with the fertility clinics. In fact, there's a rep from each of the fertility clinics on ECART and on ACART. And so they want to comply and they actually weed out a lot of the challenging cases for ECART first. And they simply say, look, ECART's not going to approve it. Let's not waste our time putting in an application, which means ECART doesn't have to reject any applications. So that is there, but it's never been used and it's not going to be an issue because the fertility clinics like the process. They prefer it was a bit faster, but they like it. So the 2 more interesting criminal provisions are in relation to payment. The first one comes under the Adoption Act because transfer of parentage at the moment is only through adoption. And if you go through a fertility clinic, you have to agree that you will adopt the child at the end to make sure that legal parentage is there. So again, in terms of its usefulness, it is not useful at all. It gets discussion, but the wording of the section is that you cannot pay somebody in consideration of the adoption or proposed adoption of a child. And again, anyone who goes through surrogacy in New Zealand or who talks to a lawyer knows very well that all you need to do is stand up in court and say, but I didn't realize I had to adopt the child. I thought it was my child. No liability because the payment was in relation to the surrogacy. It was not in relation to the adoption. And the judge nods along and conveniently forgets the fact that part of the legal advice has to be that you must adopt the child. So we'll just ignore that part of it. So we have this provision, but never going to be used because it's too easy to get around. So what I just said about that, it's not going to work because the intended parents stand up and say the payment was in relation to the surrogacy. You might think that that causes problems with our next section, which says that you can't pay any money to the surrogate in relation to the surrogacy. All right, so section 14 says that the intended parents can pay medical expenses, lawyers' expenses, and counselling expenses as long as that money goes directly to the professional. Right, so no money can go to the surrogate themselves. So if you were to pay reasonable expenses, that does seem to be a breach of section 14. However, our courts are really good at closing their eyes to section 14 and kind of pretending it doesn't exist. So when an application for adoption following surrogacy goes to our courts, the judges have developed a nice little checklist of things that they need to look at, and section 14 and payment is nowhere near that checklist. So that all kind of works quite nicely. There's definitely payment happening, but the courts are doing the don't ask, don't tell type thing, and justifying it on the basis that it's in the best interest of the child to allow the adoption, and so therefore any payment should not interfere with that. The bill decided to change things because it does make it complicated. The idea that you can't pay any money to the surrogate
when surrogates and intended parents go to lawyers and get their legal advice, it's very difficult for the lawyers to give that advice because they have to say, look, Section 14 says no money can go to the surrogate to reimburse for anything. However, the courts are probably not going to do anything about it. And some intended parents and surrogates pick up on the courts are probably not going to do anything about it. Others don't, and it does create some uncertainty. And there is anecdotal evidence of people going overseas because they didn't understand that the courts will probably look the other way. So the new bill, which in its original form was written by an MP who now has 2 children by surrogacy and was fed up with how complicated the whole system was, suggests that a clear exception is introduced to allow for reasonable costs. So what's in red there is, I think, what the current version of the bill says. I don't think that's going to survive much past Tuesday, but that's what it is now. And I think you can see that a lot of the things in the list there look like what Nick talked about in relation to the UK. I think we took their pretty diagram and we put it into our act. It all looks pretty straightforward, except for the final one, which is reasonable out-of-pocket expenses, for example, childcare, housework and pet care, which just seems incredibly vague to me. So in an attempt to clarify what reasonable costs were, they end up giving this and anything else type clause, which I think is going to raise a lot of questions as to does it fit there or does it not? The question that I'm ending the slide with is who decides what is reasonable? This is one of the most interesting parts of the bill because interesting for me and terrifying for me, because what it does is it puts the burden of deciding reasonable expenses on the ethics committee, which therefore means it puts the burden on me to write the definition of reasonable expenses for the ethics committee to apply. Right, so the idea under the new bill is that the surrogacy agreement or contract goes to the ethics committee for approval. And if they're happy with it, then the surrogacy can go ahead as long as the procedure is medically and ethically sound. So moving the idea of understanding what reasonable expenses is out of the hands of judges who have been doing this for a while or ignoring it for a while, and putting it in the hands of an ethics committee who is not legally trained is a little bit problematic for me. On the one hand, I'm quite happy with it because I know our ethics committee and I know that they'll do a fine job. But on the other hand, as a lawyer, I'm worried about having an ethics committee decide what is reasonable without having a concept of needing to be consistent over time, and also putting it in the hands of an ethics committee with a pretty revolving membership. People leave the ethics committee every year and new people are appointed. And so I'm worried that there's going to be a lack of consistency and that's just going to lead to a lot of confusion. So I think that's going to be an interesting discussion for the advisory committee on how we phrase this in such a way that the ethics committee can make the right decisions. So those are our 3 criminal provisions. The consequences regarding parenthood, there are none. There has never been a situation where an application for adoption has been rejected due to payment, even if there is quite clearly a payment going through and the judge says this is a commercial arrangement. Our judges have taken the approach of the UK courts and have basically said it's in the best interest of the child for an adoption to go through, and we'll just ignore any payments that are happening. I think Judge Ryan in re-KR put it really well. And he says that policy considerations are not within the role of this court to impose. My role is to determine this particular application in front of me. So a family court judge saying, I'm a family court judge, I'm deciding an application for adoption, that's what I'm doing. If the government wants to put in policy considerations banning commercial surrogacy, then they can enforce it, but I'm not going to. I'm going to focus on the best interests of the child. Right, and that's worked pretty well so far. Can it continue under the new bill? No. and this is the thing that I'm currently talking to our Health Select Committee about. The regulation in New Zealand, or lack of regulation, has worked because the courts just focus on the adoption application. They don't have to deal with the commercial aspect of it if it exists, and so they choose not to. But under the new bill, the Ethics Committee is required to approve both the contract and the surrogacy procedure. So both the legal and ethical side of it and the medical side of it. So this kind of approach is not going to be available to the Ethics Committee. They can't just say, look, the commercial aspects are somebody else's responsibility, because it's actually put on them. And so one of the issues that I have with this is that they are going to find a situation where they have competing interests, right? There is a surrogacy procedure being asked for that seems to be ethically and medically acceptable. But on the other hand, there is money changing hands that might be outside the reasonable expenses. So they're going to have to balance out the commercial policy objectives and what's in the best interest of all the parties to the agreement. And I think that's going to be really challenging. It's clearly challenging for the judges who have basically said, not our problem. I think it's going to be even harder for an ethics committee that doesn't have that legal background to do. And so I think that might raise some problems, and it might lead to uncertainty, which has further consequences. So my conclusions, first of all, while commercial surrogacy is illegal, it doesn't actually matter in real life because everybody just ignores the problem. ECART, if it sees an application where money is clearly changing hands, will still approve the arrangement and just advise the parties to read the Section 14 prohibition on payment again. And if the parties choose not to read it again, then ECART has done its job and it's fine. The judges are doing the same thing. Commercial policy objectives are for somebody else. So anecdotally, commercial surrogacy happens all the time in New Zealand. I am quite often asked for advice where there is a surrogacy in process, that the surrogate is pregnant and the parties are now disagreeing on the amount of payments going through. So clearly there are payments happening and the surrogate or her family now wants more money, and the intended parents are saying, I'm not sure this is legal. And our response is, no, it's absolutely not legal, but it's clearly happening. And we're also very much aware that you can only ban commercial surrogacy until the point where the adoption application is granted. And then after that, it's a free-for-all. So we have a lot of situations where intended parents and surrogates will actually say to the fertility clinics and counsellors, we're not going to pay during the pregnancy, but as soon as the adoption has gone through, we're shouting them a trip to Hawaii. And the ethics committee is like, okay, read Section 14. Right, so it is clearly happening, but it's not happening to a problematic extent that the government needs to do it. So that's basically my conclusion. Don't ask, don't tell is working so far in New Zealand, but the proposed bill has really interesting implications and it might make things more complicated. And if it does, then it's going to lead to, I think, a bit more travelling to the US and maybe popping across the ditch to Australia to go through international surrogacy.